Hello. Welcome to day one of Netroots Nation 2024, the virtual experience. My name is Denise, and I'm your virtual room host for this session. What happens to the courts if the far right wins in 2024? AKA, it's all on the line. I'm going to be the room host, and I'll be in the audience chat, making sure I answer any of your questions. If you are joining us on your mobile phone, you'll be able to turn on captions or change languages in the bottom right corner of your screen. If you are joining us from your desktop, you should have a gray bar off to the side of your screen where you can enable captions as well as language translations. Those will be a little bit delayed from the live stream, but not much. But please let me know if you have any questions or challenges accessing those features. Just as a reminder, we are virtual, but our rules and code of conduct still apply in virtual spaces. So let's please make sure we're respectful and solutions oriented as much as possible on a very, very grave topic. And if you have any questions or concerns, you should be able to also just DM me in the chat, and don't hesitate to reach out if you have a question. We'll have time for Q&A at the end. Please make sure you're using the Q&A function in the app. This way, the speakers have the ability to see that, can review questions, and select what they're going to answer. And with that, I'm going to turn the session over to our lovely panelists, and I'll see you in the chat.
Thanks so much, Denise. Truly, like, the Netroots staff that make these virtual trainings happen are the back. We could not do this without them. And it's so lovely to get to work with Denise on a courts training for the second year in a row. So super excited to be here with you all. Hello, everyone. I'm Meg Simons. My pronouns are she, they, and we're here with People for the American. I'm with People for the American Way. Everyone else is not. But we're here to talk about what happens if the far right wins in 2024, specifically around our courts. If you've been anywhere near any piece of technology over the past couple weeks, you've probably heard at least something about the Supreme Court. And while this court's term so far has been kind of a mixed bag in that it hasn't been quite as terrible so far as we were maybe expecting, the last few years have made one thing excruciatingly clear. If we let the far right take back control of the presidency and the Senate, and therefore control of our courts, they will rig our courts to make sure they maintain power and we lose the rights we need and we care about for decades to come. So that's really depressing, but there is stuff we can do about it. And the obvious answer is to vote, right? We get to vote for the people who both nominate and vote on judges. And honestly, if you leave with nothing else from this panel, I hope that you leave with the fact that you should be thinking about the courts when you go vote this year. But we can actually do more than vote. I also want to say on voting, vote all the way down the ballot, because some of you are lucky enough to get to vote for state Supreme Court justices and state judges. And those are all the way down the bottom of the ballot. So vote all the way down that ballot. Don't hit the presidency and the Senate and the House and bounce. Counterproductive. But there's more that we can do than just vote. We actually right now have a small opportunity to not just undo some of the harm Trump and McConnell and the far right did to our courts, but to actually start safeguarding our courts in case the far right does win this year's election. But we have to act fast and we have to act together. And that's why I'm so excited to be here with today's amazing panelists. Katie, Shwetika, Peter, and Keith are here to walk you through what's happening in our courts right now, how we got here, what the far right has said they'll do with Project 2025, and what we could expect from the kind of judges Trump and the far right would put on the bench. And finally, we'll talk about what we can do now to take back and protect our courts. So let me tell you a little bit about each of our panelists, starting with Katie. Katie O'Connor is a badass lawyer, fellow Southerner, and honestly the kind of lawyer I want to be if I ever get it together enough to actually go to law school. She's currently the director of federal abortion policy at the National Women's Law Center. And before that, she was the deputy chief counsel at Demand Justice, an organization doing really cool work fighting for progressive change in our courts. She also worked at the American Constitution Society, driving their strategy on voting and democracy, equality, and liberty, and litigated federal and state courts voting rights cases with the Advancement Project and the ACLU Voting Rights Project. So all around, super cool and very knowledgeable about the courts. And speaking of knowledgeable about the courts, I would say at least half of what I know about organizing, at least, I learned directly from Keith. I was lucky enough to work with Keith when he was the director of outreach at Alliance for Justice, where he's now the vice president of strategy. He oversees the justice, older advocacy, and outreach and membership teams, shaping organizational strategy and working with the program teams to maximize AFJ's impact. He's been a vital strategic thinker and organizer in at least 5 Supreme Court nominations that we've worked on together and hundreds of lower court nomination fights. But today, he's joining us in his role at Alliance for Justice Action Campaign, the version of AFJ that can say spicy things like don't vote for people who put Kavanaughs on our courts. Speaking of Brett Kavanaugh and the Supreme Court, I don't know if y'all's algorithming as hard as mine are, but I can tell you from personal experience that Planned Parenthood Votes and Action Fund is one of the groups out there absolutely killing it in their social ads and social and impact ads about the impact of the courts. And if you ever need someone to remind you why the courts are worth fighting for and how to do it, you need to talk to Shwetika. She's the senior director of campaigns at Planned Parenthood Action Fund and Planned Parenthood Votes. She co-manages a team of 11 public affairs experts who support all of their work across all 50 states, and she runs a multi-million-dollar independent expenditure campaign to help elect sexual and reproductive health champions across the country and up, and like we talked about, all the way down that ballot. This is her 5th time training at Netroots, which I just thought was really cool and wanted to call out. So thank you for being here again. And I'm really excited to get the opportunity to talk with her about our courts again. And last but certainly not least, Peter. Now, I owe Peter Montgomery a debt of gratitude because he works at Right Wing Watch, which means he watches all the crazy stuff coming from the neo-Nazis and the fascists and just the general anything from Truth Social, so that we don't have to. He just tells us what's happening, which is great. And I'm super lucky to work with him right now in his role as research director at People4 and executive editor of Right Wing Watch. He studied the religious right movement and its right-wing political allies for over 2 decades. Now, I spend a lot of time thinking about the history of the courts and the far-right attempt to take them, but when I want to know something, I go straight to Peter. He has a wealth of knowledge on the who, what, when, where, why, and the history of America's far-right extremist movements. He's written about marriage equality, religious liberty, and other conflicts at the intersection of religion, politics, and LGBTQ issues, and I'm excited for him to lay out how we got here for all of you during this training. And with that, I'm going to kick it off to my panelists to introduce themselves and anything that I left out that they want you to know about them. Let's start with Katie.
I was flattered by your introduction, so thank you so much, Meg, and thank you for organizing this and having me join.
Awesome. Keith, Peter, Shwetika, anything I left out of your bios you want people to know before we jump into our first question?
Nope, just thrilled to be here, and thanks to everyone who's online virtually.
Likewise, thank you.
Yep, I think you covered it. Thank you.
Perfect. So let's jump into our first question, starting with Katie. So Supreme Court still has so many decisions to release and only 4 days to do it, but there's been a lot in the last few days. So can you give us kind of a rundown on what in the world is happening?
I can. I want to start by saying I think this panel is really well timed. So yesterday, as most of you know, marked the 2-year anniversary of the Dobbs decision that overturned Roe versus Wade, stripping Americans of a fundamental right that had been constitutionally protected for nearly 50 years. The Dobbs decision came just 2 years after another decision, June Medical Services versus Russo. That case reaffirmed the fundamental holding in Roe versus Wade. The only thing that changed in those 2 years between June Medical Services and Dobbs is that Ruth Bader Ginsburg died and Amy Coney Barrett replaced her on the court. So Dobbs is such a crystal clear symbol of how the Supreme Court has become a fully political entity, sort of untethered by the rule of law. And so having this panel on the near anniversary of Dobbs, I think, is really fitting. This year, we're continuing to see the results of the politicization in the cases that the court is deciding. And so I'm going to walk through the cases that are before the court and then talk a little bit about cases we might see in the coming years. And I've divided this year's cases into 4 buckets. There are the cases that are still pending, and I'm going to hold this for last, but there are also the losses and the wins and the near misses. So one of the losses is a case called Alexander versus South Carolina State Conference of the NAACP, which challenged the congressional map that was drawn for the state following the 2020 census. A 3-judge panel of the U.S. District Court for the District of South Carolina had unanimously ruled that the legislature had engaged in racial gerrymandering in drawing that district. But the Supreme Court reversed that ruling, attributing the legislature's actions to partisan gerrymandering rather than racial gerrymandering. The court said, in essence, that while racial gerrymandering is unconstitutional, partisan gerrymandering is fine. And so as long as a state can justify its maps using partisanship, the effect of splitting Black voters doesn't matter. Another loss this year was in the case of Garland versus Cargill. So following the 2017 mass shooting at a music festival in Las Vegas, in which 58 people were killed, the Trump administration issued a regulation banning bump stocks. These are devices that basically convert semi-automatic rifles into machine guns. A gun store owner challenged the regulation, and the court ruled in his favor, rejecting the government's argument that bump stocks could be banned pursuant to the National Firearms Act. As is often the case with the court's more unpopular rulings, this decision focused almost exclusively on sort of the mechanics of the gun's inner workings and ignored entirely the really devastating consequences of the court's opinion. There were also a couple of wins this year, although I'm using wins in air quotes because they're only wins, as you suggested, Meg, in the sense that we didn't get the absolute worst outcome possible. One of the wins came just last week in a case called United States versus Rahimi. In this case, the plaintiff challenged the constitutionality of a law that bans gun ownership by someone who is subject to a domestic violence restraining order. So the Supreme Court rejected the challenge, confirming that abusers who are subject to restraining orders don't have a constitutional right to own guns. This was the obviously right decision, but it's still technically a win. And the fact that this case exists just shows how out of control Second Amendment jurisprudence in particular has gotten in this country. Another win this year was in the case of Moore versus United States, which involved a challenge to a one-time tax on U.S. taxpayers on their shares of foreign corporate earnings. The court ruled pretty narrowly in the case, rejecting the broad and extreme arguments pushed by the challengers that would have severely undermined Congress's power to levy taxes. This, again, is technically a win, but the fact that such an extreme case made it to the court in the first place is really alarming. Next up, we have what I'm calling the near misses. So the first near miss is one that you're probably familiar with: Alliance for Hippocratic Medicine versus FDA. In this case, a group of anti-abortion doctors challenged the FDA's approval of mifepristone, a medication that's used in more than half of all abortions in this country today. This drug was approved almost 25 years ago and has a proven safety and efficacy record. The Supreme Court ruled that the doctors didn't have standing to bring the challenge in the first place. So basically, the court acknowledged that the doctors weren't actually being harmed by mifepristone's approval, and so they didn't have the right to challenge it in court. It is a huge relief that mifepristone will continue to be available in the near future, but I call this case a near miss because this may just be a temporary reprieve, since we know other opponents of abortion are already waiting in the wings to bring another challenge like this to mifepristone. Another near miss came in the case of Atchison versus Lawfer, which involves the Americans with Disabilities Act, or the ADA. So the ADA can be enforced through lawsuits brought by the federal government and by private individuals. And cases bought by private individuals are really important because the government doesn't have the bandwidth to bring all the suits that are needed. So some disabled people, called testers, investigate compliance with the ADA and bring cases when they discover violations of the law. The question in this case was whether testers have standing to sue businesses for discrimination. The court ended up dismissing the case on mootness, so it didn't get to the underlying question of whether testers have standing. That is a near miss, because we'll almost certainly see another challenge to the standing of testers in the coming years. So those are the cases we've already gotten. I'm going to talk about a couple of cases that we're still waiting on. The Supreme Court has announced that it will issue opinions tomorrow, Thursday, and Friday. Let's hope it's done by Friday because we all need a break. But there are still a bunch of cases pending. So first, there's a case about whether pregnant people will be protected by a federal law that requires emergency rooms to provide stabilizing care to somebody who's experiencing an emergency medical condition. In the 2 years since Dobbs, we've seen devastating reports of abortion bans forcing people with dangerous pregnancy complications to travel for hours, often crossing several states, to access care after being turned away from their local hospitals. The Emergency Medical Treatment and Labor Acts, which we're calling EMTALA, which is still very clunky, I realize, was enacted by Congress in 1986 to ensure that any person who's experiencing an emergency medical condition will be given stabilizing medical treatment. For pregnant people, abortion care can be urgent and necessary stabilizing medical treatment. And so the Department of Justice sued Idaho in the fall of 2022, shortly before that state's extreme abortion ban went into effect, arguing that to the extent that the Idaho abortion ban conflicts with EMTALA, it is preempted by the federal law. The Supreme Court heard oral argument in the case on April 26, and we're expecting a decision later this week. But I want to just say that regardless of what the court does in this case, it's important to point out how bad Dobbs has been for pregnant people and how quickly abortion access has devolved in this country. We're 2 years out from Roe being overturned, and we're literally at the Supreme Court begging for abortion care when it's necessary to save lives. The last case I'll talk about is actually two cases that have been combined: Relentless versus Department of Commerce and Looper Bright Enterprises versus Raimondo. These cases deal with how administrative agencies like the Environmental Protection Agency or the Consumer Financial Protection Bureau interpret laws that they administer. Though we don't have a decision yet, it seems pretty likely that the court is going to drastically narrow the ability of agencies to do their jobs. This is actually just a huge power grab by the courts and by the Supreme Court, because it would essentially be the court would be taking for itself the authority to interpret the rules that govern everything from medication approvals to environmental protections to gun safety standards. And it would, meanwhile, seriously hobble the functioning of the federal government. So those are the cases that are before the court. I know this has been a lot. I've just rattled off a whole lot of information. I do want to end by pointing out the common thread in all of these cases is just how emboldened conservative judges have become. The imbalance on the Supreme Court has sort of signaled to lower courts that they can do more and more extreme things and that they'll have a willing audience with the justices. So, of course, Supreme Court justices matter, but lower court judges really, really, really matter too. Donald Trump was remarkably successful at stacking the courts with increasingly conservative judges, so much so that more than a quarter of federal judges are now Trump appointees. And so it's important that we continue while we have the time to push President Biden to nominate and the Senate to confirm as many judges as possible in order to bring some balance back to the courts. And I'll stop with that for now.
Thanks so much, Katie. Sorry, I struggled with unmuting myself. There's a lot happening, to put it mildly. And I want to pick up on kind of the last point you made, and I'll pose the question to you, but I want to encourage your fellow panelists to hop in as well. One of the things that keeps me awake at night is the fact that even when we get like a win with the Supreme Court, like nothing feels safe because we've seen they did it like in Dobbs, they did it all the way back in like the cases that led up to Janice v. AFSCME. Like, to your point about like the Supreme Court justices getting bolder, they are literally writing in dissents or in decisions like, yeah, we didn't like get it this time, but here's what I would do like if I were you and wanted to challenge this again. Basically, like, are there, in addition to all the other things we should be concerned about, like in even these kind of like wins, are there things that we should be aware of that like Supreme Court justices are already kind of like flagging coming down the pike? And I apologize. It's basically like asking you to remember every single dissent that has been written this session. So please feel free to tell me no, I don't know. But you know, what should we be concerned about?
Yeah, I mean, that's why I use the term near misses, because certainly from the dissents and from the oral argument, you heard, you know, the justices who knew they were going to end up on the losing side sort of grasping at straws, trying to figure out what case could be brought next that would be successful. I think the Mifepristone case is a great example of that. The judges who were in the minority in that case spent a lot of the oral argument asking about, well, if these plaintiffs don't have standing to sue, then who does? Because it is impossible that we can just get rid of this case and not have another bite at the apple. And so I think you see that in a lot of, you know, the cases where there are sort of procedural decisions being made. The more conservative justices, the justices in the minority, are often signaling to litigants what they need to do in the future in order to have a more successful case.
Yeah, and I'll jump in on that from more of the sort of electoral hat, if you will. I think it's been fascinating to see just in the increase in the engagement on state level Supreme Court races between 2022 and now. You know, I think the question here isn't just like, when will we feel safe again? It's that we just aren't. Like, I think it's just that it's more like we are just in a place where the more absolute power that people are going for it's been clarified and revealed. And maybe it's a good thing or a bad thing, I don't know. But what is true is that there was a security blanket in the state in our country with the national Supreme Court as sort of a backstop for several decades. And now that backstop has taken away, the importance of state Supreme Court has become critical. And from my sort of electoral hat, from my independent expenditure hat, I think the thing that I don't know if hope is the right word, but the thing that I would cede is that people aren't dumb and they see what the national Supreme Court is up to, which is why, whether it was in Pennsylvania Supreme Court race last year, Wisconsin Supreme Court race last year as well, or the ones coming up this year, you see that the national Supreme Court has lower favorability in these states than their state Supreme Court. And that's not because that lower favorability is because people are paying attention. That's not because voters don't know. Voters know. And in fact, now that we have the national Supreme Court making it very clear what their priorities are, we have an ability and even unfortunately an opportunity, or fortunately, depending on where you think of it, to use that to bring more awareness to what state Supreme Courts do. And I think the more we get to educate voters, whether it's from a C3, C4, or even an electoral perspective on what their local state Supreme Courts are capable of or are responsible for, I think the more awareness we're bringing to voters in states, especially in red states, where this is particularly important. And a really good example of such a state currently is Ohio. Voters in Ohio overwhelmingly voted last year, something like, 2 million voters cast an off-year vote for a ballot initiative in Ohio to protect abortion access, the right to reproductive freedom, I think is what was right to reproductive freedom with protections for health and safety amendment. That's what I have it in front of me. But the thing that voters now have to be educated about is they didn't just vote for that ballot initiative and now all their abortion rights are protected. No, it's now all of what they voted for is going to be faced at the Ohio State Supreme Court. And that one is a particular one where the balance of the court is up this year. We have the ability potentially to change the balance of the court and make that court more pro-abortion rights, so that then the court as an institution can actually do what the voters have already said they want. And I think all of that is exhausting, to be very clear. I think that means we now have the work across our movement and across, not just across our movement, but across decades to do this at the state level until we are in a different composition at the national level.
Yeah, that's like such a good point. And it does feel a little bit like a Lucy with the football situation where like we keep saving it and then they just like yank it away and they're like, now we're going to do it again. And it can be really exhausting, but like we have to keep doing it. We're trapped in the world's worst game of ping pong. Like we just have to keep hitting it back because otherwise we lose, right? And I want to talk to Peter about how we got here. But first, I actually want to give Keith a chance. They have a really cool tool that will actually show you if your state has, like, how your state Supreme Court judges are selected. And I want to give Keith a chance to plug that because I obsess over it. Keith, do you want to talk about your map?
Yeah, thanks so much. So this is our C3 affiliate, Alliance for Justice, maintains a state court justice hub. And it's a 50-state map on the selection processes, but not just the selection processes. So, for instance, whether you vote directly on a state Supreme Court justice or your governor appoints a state Supreme Court justice, but also the makeup of the current court for your state Supreme Court and when the next vacancy is. Vacancy being either your next election, if it's an electoral state, or due to mandatory retirement rules when the next appointment would happen, all aimed at educating voters and the public about how they can weigh in and advocate for fair courts in their state.
Because another thing, like those state Supreme Court justices are vital now. They're making decisions right now, right? But another thing we have to think about is that, like, it is not uncommon for a judge over the course of their, like, judgery, time as a judgeship, to go from state Supreme Court justice to Supreme Court justice, right? Like that was the path Sandra Day O'Connor took. Like that, those state courts are often kind of like I don't want to call them a training ground because they're obviously so important, but like they are a place where when senators, when the president is thinking about nominating someone to the federal courts, that is a career path that they consider, right? Is state Supreme Court justices. So like you can both, you need to think about those courts both for right now and for like what happens in 10, 20 years. And I know it's hard to think about the next 5 minutes right now because everything is chaos. But like we do have to be thinking about what happens in 5, 10, 15 years. Speaking of the ever marching of time, Peter, this didn't happen. It feels sorry, that was my dryer. It feels sometimes like this happened overnight, right? But we know it didn't. This has been like a concerted effort by the far right to and now they've helpfully, not so helpfully, laid out exactly what their next steps are too. So like before we look at next steps, like can you tell us like how did we get here? How did the far right so thoroughly entrench themselves in our courts?
Yeah, thanks. It's great to be here with all of you. That's a very big question that I'll try to cover very quickly. I would say there's four big picture things. The far right had a strategic, long game plan with an explicit goal to take over domination of the courts. They had massive amounts of money to put into that goal, to achieving it. We had unprincipled Senate Republicans willing to abuse their majority power when they had it. And we had Trump's victory, which was based, I think, largely on a deal he made with the religious right over the Supreme Court. So start with the long game. The right's hostility to the Supreme Court goes back a long way. It goes back to defiance of the Supreme Court's Brown v. Board decision in the 1950s, and that generated backlash and defiance in the states of the old Confederacy and in counties within those states. We also had religious right folks very upset about rulings in the 1960s upholding separation of church and state, rulings against sort of state-sponsored prayer and required Bible readings in public schools. And we had Roe v. Wade, but contrary to a lot of popular mythology, it was not Roe that really mobilized the religious right movement to get involved in politics and to try to take over the courts. It was efforts to enforce Brown v. Board of Education, and it was when the federal government began to move to take away tax-exempt status from racially discriminatory schools, and Bob Jones University in particular. And there were some smart political strategists led by Paul Weyrich who used that case to mobilize hostility toward the court from conservative white evangelicals. And they grabbed onto abortion and opposition to abortion as a more politically palatable issue for them to organize around, rather than organizing in defense of racist policies. But it was part of this the movement that really got things going. Then in 1971, Lewis Powell, who was shortly to be named a Supreme Court justice, sent a memo to the Chamber of Commerce warning that anti-business left was taking over American institutions and urging corporate America to fight harder and to fight big. And they did. His memo led to massive investments by right-wing corporations and foundations that really built what is now the modern infrastructure of the right wing in America. And, key to that was the Federalist Society and the Heritage Foundation, two organizations that have been intimately involved in the effort to take ideological domination of the federal courts and the Supreme Court in particular. And it was not just about, has never been just about Roe or even LGBT equality, but really a way to repeal the New Deal and to roll back a century of progress, to reverse the federal government's ability to protect communities from corporate misbehavior. And so it's a much bigger picture that we're looking at. The Citizens United ruling in 2010 by the Supreme Court opened the floodgates even further for money to come into our politics, and especially state Supreme Court races. And it was already a big problem in the state Supreme Court races that Bill Moyers and the Brennan Center had documented sort of the flood of big business money that was leading to attacks on justices and efforts to move the judiciary, not just the federal judiciary, but the judiciary at large, to the right. Leonard Leo, one of the people who was the architect of that takeover at the Federalist Society, and people are familiar with some of the groups he funds, the Judicial Crisis Network. He's a master of raising and spending dark money, and he funnels millions and millions of dollars through secretive networks of nonprofits and for-profit companies. And in the last decade, he sort of added a big focus on state courts to his long-running efforts on the federal courts. And you can look for a really great report that ProPublica did in October of last year, October 2023, on his focus on the state courts and the efforts to tilt the judiciary to the right at that level too. And Leo, who has always had no trouble raising money, now is playing with an even bigger pot. He was given $1.6 billion by an industrialist in the last couple of years, so he's feeling his oats. The other thing, of course, was Mitch McConnell, Senate Majority Leader's just complete unprincipled abuse of power. He slow-walked Obama nominees so that there were a lot of vacancies open when Trump was elected. And of course, most notoriously refused to allow the Senate to consider President Obama's nominee for Supreme Court for an entire year, which gave Trump a vacancy waiting for him when he came in. And McConnell's actions were just a real sign of the priority that the Republicans and their far-right funders have placed on the Supreme Court. And then, of course, Trump's victory is really what brought us the 3 new MAGA justices on the court. And Trump won partly because the right-wing investments over the years in talking to the constituencies about SCOTUS meant they were more successful, frankly, at making the Supreme Court a turnout motivator. And particularly, the Supreme Court was a centerpiece of the deal that Trump offered religious right leaders to win their support in 2016. He said explicitly, "You put me in office and I'll give you a Supreme Court that will overturn Roe." That helped them convince them to mobilize their constituents to put him in office. And he did it. He returned the favor, fulfilled his promise. So I will just say that things can and will get worse if Trump is elected again. Both the Supreme Court and the appeals courts are likely to be pushed much further to the right than he was able to do already in his first term. I'll just note that there's an effort by a number of the religious right groups led by the American Family Association that has a big explicit project demanding that Republican presidential candidates and senators apply an explicit religious test for judicial nominees, considering only judges and potential justices who meet their biblical worldview standard. And as outrageous and unconstitutional as that is, they're being quite brazen about it because, given their success so far, they're confident and arrogant. So I'll stop there.
Wish there was something I could say that wasn't just like truly horrifying, Peter. Let's talk about something else. But unfortunately, that's kind of what I got. But I do want to lift up a couple things from there before I ask you about Project 2025 and depress us all over again. I wanted to lift up the way you talked about how it started with like Brown, and then Brown kicked off, anger about separation of church and state, which then they targeted and zeroed in on reproductive rights. And now we're seeing them, the Supreme Court just announced last week, I have no concept of time anymore, but they just announced recently that like they're going to tackle whether trans kids can access, gender affirming care next term. And like, this is why we all have to make sure our activism is like intersectional, because they attack us on different fronts to attack us on all fronts, right? Like they use these opportunities to try and like drive action that they want to then validate attacks on other communities. And so like, if your activism is intersectional, like I don't want it. Like you have to be thinking across all of these like rights and issues that we care about, because our opponents are, and they are willing to set precedent attacking one group to then turn around and attack another group. I meant for that to be more inspiring, but it just ended up being scarier. So apologies for that.
Well, and I would say that there's a ugly version of that on the right, which is you have plenty of people in corporate America who maybe, don't really care that much about LGBTQ equality. They're not opposed to it, or who might not even be opposed to have people having legal access to abortion. But they're willing to build coalitions with folks who wanted those things in order to get judges who would help them turn back the ability of the federal government to regulate corporate behavior and other things they wanted to do to sort of shrink the size of the federal government. And so they were willing to push hard for judges who have a commitment to overturning Roe and destroying LGBTQ equality. So it's kind of a perverse form of intersectional thinking on the right.
It's like if you join the like face-eating leopard party, at some point the leopards will eat your face. And like that, it feels like that's something that like this coalition they've built around these kind of like scare tactic issues that they use. Like it's something that still doesn't, those people still aren't quite getting it, right? Like at some point they will come for you. Speaking of them coming for us all, Project 2025. Wow. What a nightmare. Can you tell us from like a court's perspective, and I want to be mindful of time because I want to make sure we hear from Keith and Shwetika. So maybe in like 2 minutes, what have they already told us they're going to do with the courts? Like,
yeah, I'll be really quick. I mean, one of the interesting things about Project 2025 is that it is a plan for taking over the executive branch and using all the power of the executive branch to create as much harm as they can and to centralize power in the president and undo checks and balances. So it's not explicitly about putting the right kind of judges in the courts. They've got other, projects on that. But the one way Project 2025 does talk about using the courts is kind of doubling down and bringing the federal government into the sort of row strategy that the right used of bringing cases, constantly giving the right-wing majority on the court the opportunity to overrule by pushing cases up for them. And now we're seeing that, as we've already mentioned a little bit, on a range of other issues. And Project 2025 lays out some of that explicitly, saying, well, the court has gone this far, but we'd like them to go this far. So we need to push cases to them that will encourage them to go further. So I think that's, and Project 2025 is the full bore agenda across every issue that people could care about, from environment, you name it. And so what they are talking about doing is using the federal government, bringing that into alignment with right-wing groups that want to take advantage of how far the court has gotten already to maximize the damage that they do.
Speaking of the damage they've done, Keith, you and I were lucky enough, to get to work together to fight the nominees that Trump was putting up when he was president. We got to see up close and personal the blog posts defending the original KKK and the pamphlets they supported having passed out that claimed birth control would kill you, and all the other amazing things that came out of those nominees' records. So can you tell us, like, if the worst happens and the far right wins in 2024, what, from the first go around, like what kind of judges can we expect from a second Trump presidency now that, he would kind of be unleashed, he wouldn't have to worry about winning a re-election? And what should folks kind of be prepared to do if these people are nominated? Like, how do you even push back on that?
Yeah, well, one thing I'll point out and start out with is that as a candidate in 2016, Trump actually promised a litmus test, 2 litmus tests. He promised to nominate judges and justices committed to 1, overturning Roe v. Wade, and 2, the Affordable Care Act. And you know that saying about believe them when they tell you who they are? He nominated judges committed to all of that and more. From the district courts up to the Supreme Court, he worked with the people that Peter mentioned, Leonard Leo and far-right conservatives, to stack our courts with ultra-conservative right-wing ideologues dead set on dismantling our rights. And these weren't the run-of-the-mill Republican nominees that we had seen under previous Republican administrations. They truly went deep into the far-right movements and put their lawyers on the bench. Many people have heard of Brett Kavanaugh and perhaps Amy Coney Barrett and Neil Gorsuch, but it's really important to note that it doesn't end at the Supreme Court. Trump nominated 234 judges that were confirmed. He nominated more, but 234 were confirmed, which is nearly 1 in 4 of our federal judiciary. Some of the worst have started to become some household names. One I'll start with is Matthew Kacsmaryk, a judge in the Northern District of Texas. He is so reliably conservative that the right engages in what we call judge shopping, filing cases in his and other districts with judges that they know will rule in their favor because they're the only ones the case can be assigned to. In this position, Kaczmarek has reinstated the Remain in Mexico policy, blocked mifepristone, blocked Affordable Care Act LGBTQ plus protections, blocked closure of the gun show loophole, and really just become a standard bearer of what we can see from Trump's district court judges. And too often we gloss over the district courts, which are the trial courts, because of the influence of our appellate courts. But Kaczmarek alone has shown that each and every one of these judges matters. Another one I'll highlight is a Sixth Circuit judge, Amul Thapar. Before Dobbs, he was on record saying both Roe and Casey were wrongly decided. He ruled for an anti-transgender professor wanting to misgender students and would have ruled against Flint residents suing over lead. He also wrote a book defending and lauding Justice Thomas as the people's justice, essentially auditioning for a seat. Also auditioning for the Supreme Court is James Ho, a judge on the truly out of control Fifth Circuit. He recently has spoken about cancel culture and opposing hiring clerks from Yale, called abortion a moral tragedy in a decision requiring the burial or cremation of fetal remains, and ruled on Dobbs itself when it was at the Fifth Circuit. He also ruled on Rahimi about whether someone on the domestic violence registry could access a gun, and wrote not one, but two opinions and one anti-transgender case just so that he could concur with himself. He, in particular, is in that audition mode, which could happen. A conservative coalition, including Christian nationalist groups, have put Ho on a short list that they've greenlit for the Supreme Court for a future Trump administration. Another one that at the time of her original nomination was floated to be elevated to the Supreme Court is Naomi Rao, who actually replaced Kavanaugh on the DC Circuit. As head of a really important regulatory agency, Rao dismantled numerous protections the Obama administration and others had put in motion, including Title IX protections for survivors of sexual assault, and engaged in some really ugly shaming of survivors in the process. These are really just a few of the 234, and they're already issuing decisions that matter and that are impacting our lives. So we cannot stress enough, he made these commitments and did it. These commitments, if anything, have only gotten worse and more entrenched within the far-right movements, such as Project 2025. It will be these movement judges that they are putting on the bench in a future administration, and why it's so important, as Katie mentioned, that we fill every seat before the end of the 118th Congress to try to take back our courts and undo some of this damage.
And on that note, I want to toss it straight to Shwetika, because the Reaper Rights movement is out here, like the organizing coming out of y'all's community is just like top tier, especially when it comes to combating these judicial attacks on our reproductive rights, educating people about the courts. Can you share lessons you've learned from the field and kind of get us into the discussion of what people at home can do now to shore up our courts and also vote in November? I'm gonna get it stenciled.
I was gonna say you can start with that and end with that, but it's certainly not everything. And I can be quick. I know we want to save some time for the Q&A. I think you kind of just said what I would say, which is this is, everything we've been saying this afternoon, like we are in the fight for our lives, for all our freedoms, not just, issue by issue. And our courts now are the front lines, not only the National Supreme Court, but the state Supreme Courts, the district courts, as somebody mentioned. So because abortion access, opponents of abortion access aren't stopping at abortion. They're going after IVF. They're going after birth control. They're going to come after not just other freedoms that we have in making decisions about our own bodies, but they also are the same groups of people, the same names, Leonard and Leo being one of the bigger ones, going after equality in terms of LGBTQ rights, in terms of voting rights, democracy itself. So because so much is on the line, it is so important for groups, not just within the reproductive movement, but across the board, to take this election very seriously. I am very sensitive to saying that this year because we know that we can't just tell communities, particularly communities of color that show up and show out and vote to save our democracy every year, that we need to vote. But I would boil it down to that this year, the difference between a President Trump and a President Biden in 2025 is potentially whether or not we ever have elections again, whether or not we ever have the ability of a president to be challenged in the way that our current democracy allows. And it is really, it is really going to just come down to state by state. So what people can do from home is really get informed, first of all, on what your state Supreme Court is. I remember being in this work in the state when I lived in the state of California and not realizing that my state's Supreme Court judges were nominated through the voting process, and then needing to educate myself. But that was me doing that because I worked in politics. Most people didn't know that Supreme Court judges get elected in many states, and I would pitch Keith's map again on figuring that out. But we have, whatever the process is in your own state, I think that's a really important place to start. And if your judges are elected through elections, there are a lot of them going on this year. Ohio was already named. Montana, another really critical one. That state Supreme Court believes the Constitution of that state, interprets the Constitution of that state as having an access to abortion protected. So if the balance of that, if the composition of that state Supreme Court changes, that future state Supreme Court could interpret the Constitution as not having that protection. So the entire ability for Montanans and surrounding states could hinge on that state Supreme Court. So there's a lot to start just from there. But I think the last thing that I will just say is that it's really harkening back to your earlier comment, Meg, of like the intersectionality and the need for that. It really just isn't about the reproductive movement. It really is like a full-scale attack on all our freedoms and democracy. And so I think Project 2025 is such an important thing for people to understand. It kind of sounds like, it doesn't sound like much when you just say it like that. And I personally am excited and hopeful that on our electoral side, we take some of those really horrible things and distill them down to what people need to actually know about what these people are promising. Because fundamentally, we need to keep reminding voters and the media and donors, etc., that we have to look at what these people do, not what they say. They will happily lie about what their intentions are, but we have a very clear, literal guidebook of what they intend to follow, and they do not intend to make the mistakes they made in the first Trump administration. So I also think the presidency here is so critical. But I could keep talking about that, but I know we want to pivot to Q&A, so we should do that. I'll toss it back to you, Meg.
Yeah, absolutely. So there is only one question in the chat, so I'm gonna ask another question and then give folks a chance to put more questions in the Q&A, because I want to get to the other thing that I know we can do. And I know Keith and Katie can absolutely talk about this, so I'm going to toss it to the two of you. But we have the opportunity between now and the end of the year to actually get the Senate to confirm the fair-minded judges that President Biden is nominating right now, right? That can help change the balance of whole circuits. In like when you work on the right nomination, it can help get amazing people like Ketanji Brown Jackson, who's in the background of Katie's background, on the federal bench. And Katie and Keith have been working on Jewish nominations for like a bajillion years. So I want to toss it to the two of you. How can people get involved in that process? Like, what is that like? How can you make your voice heard on a lower court nomination?
Keith, do you want to start?
Sure. And I think this also ties back to this premise that far too often people think about our courts as almost akin to an ivory tower that are removed from everyday life and not actually an avenue to action and achieving change. But and it also goes back to November. what we can influence is, one, who is in the White House that nominates and who is in the Senate that confirms judges. And right now, given where we are, we have a lot of opportunity to confirm some truly outstanding attorneys to the bench. The most important thing you can do is call your senator and tell them to prioritize judicial nominations and filling every seat before the end of the 118th Congress. That includes before Election Day, but then also looking at the full calendar year, including as they come back for a lame duck session. It is critical that senators hear from constituents that amidst everything going on, everything crossing their desks, amidst the culture of dysfunction and gridlock, that judges are still something that we can do. And every single vote matters on them. So that's the top thing that I would want people to do today, tomorrow, next week, and on.
Yeah, I will just add that, we are all fully aware of how dysfunctional Congress is, in addition to just the personalities that are there and the dysfunction that flows from that. There is also, the filibuster in the Senate, and now a House that's controlled by conservative, extremists. Legislating is not something that Congress does very often in times like these, and actually confirming judges is one thing that can get done and does get done. That's why we do see like Biden having near parity with Trump in terms of the number of judges that he's confirmed. That's because it only takes 51, senators, and it doesn't take a vote in the House. So I agree with Keith. We just have to keep telling our senators that this is a top priority, knowing that it's A, so important, and B, sort of the only thing that they're going to get done in the near future anyway. So this is a great use of their time. I think that leadership in the Senate agrees with that, but the more they hear from their constituents, the more they're going to prioritize judges, which is what they need to do.
So I want everyone to get out like a pencil and pen or your notes app, because, it's 2025 or 2024, or tattoo it on your arm. I don't care, but I'm going to give you like the rundown of like, here is your action list. You showed up to this training or you're watching this afterwards on social media. These are the action items I want you to take, right? First, you're going to go to, and I'll drop this link wherever you're watching this. You're going to go to people4.org/fair maps, and you're going to click on your state, and you're going to figure out if there's a nominee in your state that you could call your senator about right now. You're going to figure out, like, is there a district court nominee? Is there a circuit court nominee? What's happening in your state? So you're going to figure that out. Then you're going to pick up the phone and call. I know calling is scary. I know as a millennial, we hate doing it. You're going to do it anyway. You're going to pick up your phone. You're going to call your senator, and you're going to say, hey, my name is X. I'm a constituent from Y, and I would like you to confirm fair-minded judges. Thank you. It takes 30 seconds. Then you're going to hang up. Then you're going to go to vote.org or any organization that has voting resources. You're going to make sure you're registered to vote. You're going to make your voting plan. Where are you going to go vote? What day are you going to go vote? When does early voting start? Answer all those questions. Then I want you to pick 5 friends and text them about their voting plan. And all make a little coffee date to go vote together. Because the more people you get to go vote with you, the better. And you can even call about judges on the way to vote, because they can also confirm judges during that lame duck period. So it all really circles back together. And then you can just kind of repeat the process. Cool? You can watch the reel again. I know I speak fast. Just keep watching. Write it down. You'll be good. All right. We had one question. We have a couple minutes left to answer it. Hold on. Navigating. Okay, we had one question. Are there any strategies that don't allow conservatives to just run to the Fifth Circuit, which, as we established, is banana pants? Any chance the Supreme Court would ever be expanded? Are there efforts on that? What do we think, panelists?
I will take a crack at the second piece, because that's more my awareness. I mean, I think there's a case to be made that the Senate needs filibuster reform, and that this is a chance. This year, the balance of the Senate potentially could yield that we could have a Senate majority, if we, knock on wood, protect the majority that is currently, but also evolve that majority into being one that is open to filibuster reform, then not just Supreme Court expansion, but other federal level things could be on the table. But I think that's the part of that question I can take. I don't know about the other one.
I'll just weigh in. There are some other bills that are in the Senate, and I know I just got done saying that the Senate can't get anything done, but there is legislation that would address some of these, some of the sort of unfairness that we're seeing in the courts, specifically, as Denise mentioned, conservatives running to the Fifth Circuit and to Matthew Kacsmaryk in particular, because they know the audience that they'll get there. And so I would encourage your members of Congress to support these judicial reform bills. There are a number of different options. There are reform bills that would institute a code of conduct for Supreme Court justices who remarkably are not subject to any binding code of conduct. But there are also some ideas out there about how to prevent judge shopping, like conservatives going straight to Matthew Kacsmaryk. And so look into those opportunities and encourage your members of Congress to support them.
I'm so glad we circled back to that Supreme Court ethics piece, because even when we're talking about a terrible judicial nominee, I cannot let the phrase Clarence Thomas is the people's justice go unaddressed. I know we only name checked it during the Multhapar section of Keith's notes, but it's still terrible. So we definitely need Supreme Court ethics reform. It is a hot mess. We are at time. So I am going to take just a second to thank our amazing panelists for sharing this information today. I don't know about you, but I feel a lot more prepared and hopeful and ready to go call my senators, both my ones in Maryland who will listen to me and my ones from my home state of Texas who will not, because they still need to hear it, even if they're going to do the wrong thing anyway. So I'm going to go call my senators. I'm going to go check my voter registration. Thank you all so much for being here today. I am so glad I get to work with you, and I'm so glad people got to hear all the amazing knowledge you got to bring to the table today.
Thanks, Meg.
Thanks, Meg.
Thank you, Meg.
Thank you all.
Thanks, everyone.